And Ms. Chapin, is there anything that you want to tell the court at this time?
Sure, good afternoon, Good afternoon, Your Honor. Good afternoon, Your Honor. As I appear before you in this court today, I reflect on the past few days and weeks and months that I've been asked the question by many, are you ready for whatever decision the court may rule? Your Honor, honestly, I'm not. But what I am ready for is to continue walking out my faith in God. I do believe and have believed from day one that by His grace, He will see me through. Today, I stand before you stronger, and I give all thanks and glory to God for His grace, to my mom and dad for their love, morals, and strong faith that they embedded in me as a child and adult, though they are no longer here with us. To my siblings for their love, support, faith, and believing in my strength to persevere on days I felt I just couldn't go another mile. To my church and faith family who has stood by me with open arms through it all, constantly reminding me to keep my faith in God's love and grace. And for the many beautiful souls I've met along this journey, this past year and a half. I've seen the face of God, Your Honor, through turning my pain into my passion, my misery into my ministry, while volunteering at the homeless shelters. Instead of asking myself why this has happened, I tell myself, why did this happen for me? Life is truly about a journey and not the destination. I will continue walking out my faith in God and serving and advocating for my unhoused brothers and sisters. Your Honor, hate has created many problems in our world today, but has not solved one yet. With that said, whatever this court rules today, I will continue to stand strong in my faith and God's grace, along with my own anthem I've had throughout my years. I did not come to teach you. I came to love you. It is my hope that love will teach you. Thank you.
Okay, thank you. And now it comes the difficult task that this court has in fashioning a sentence that is appropriate in this case. To do that, I have to look at something that is individualized to you, Ms. Chapin, taking into consideration what is the general threat that you pose, also taking into consideration the seriousness of the offense and any needs that you may have. And any sentence that I fashion needs to be the least restrictive, taking into consideration those things that I've talked about. And I always start out this conversation by looking at the offense as I understand it. The crime, endangering the safety of others, goes to basically the core concern that society has. We want to make sure that people are safe, especially in their homes and with their family. In this case, the victim ended up in a comatose state because he had a large amount of barbiturates in his system. He was not prescribed any of those barbiturates, and one of them is a drug that is primarily used to euthanize animals. The victim's son was able to tell law enforcement where they could find these drugs in the home because of the probably pattern of what had happened, including the euthanasia drug, I think, being able to be found in in his truck in a lockbox, because that's where it would have been. And as I read through the criminal complaint, the PSI, and the various things that I've read, it indicates that these issues with the victim started in July, when he started having some balance issues, suffering from vertigo-like symptoms. But then, as I indicated, it ended up with him being at the VA hospital in that coma. This case has taken a toll on GC and his children. The public nature of a criminal trial is not something that anyone wants to go through. And GC just wants this chapter in his life over. GC has written both to the PSI writer as well as to the statements to this court about the effect that this incident has had on his health. For a year following the offense, he noted that there was concern that he might have permanent heart damage. Luckily, that has been resolved through exercise and working with his cardiologist. GC has continued ongoing problems with parts of his body that stem from him having to be put in restraints while in the hospital for his own protection after he woke up from that coma. He's afraid that those injuries may never be fully healed. GC's children, from what I can understand, had suspicions about you from the beginning, and you can see that throughout the criminal complaint in the PSI report and also the statements that they have made to this court. Regardless of their feelings towards you, and you've indicated that there might have been some other issues or some other events that were more positive, regardless of any of that, they were incredibly traumatized by seeing their father in the hospital, having limited access because of the COVID restrictions, and then also seeing him in the aftermath of that recovery. One of his daughters had to fly here from Washington, and when she got packed, she decided she better bring something in black because everyone was saying, we're not sure that your dad is going to make it. JC's ex-wife was also able to describe the effects that this had on the children that she shares with him. Watching him wake up from the coma and the psychological effects that it had on him, that is something that will be with them forever. And their life has been changed forever because of that. I note for the record that this is a circumstantial case, but circumstantial cases can be just as good as cases with direct facts. The circumstances are based upon the timing between GC drinking the coffee and the symptoms that he had. Time between his last memory and when you called 911. Changes in his power of healthcare attorney, home ownership, a hurried marriage, looking for financial independence, the missing mortar and pestle from the residence, your internet searches, and I've heard more information about that in terms of looking for flights and looking for property, and then also the suicide attempt that you made. That is one of the factors that, when looking at the jury instructions, that is something that might have come in, showing a consciousness of guilt. You continue to profess your innocence, but you also realize that the state could have proved you guilty through those circumstantial cases, those circumstantial issues. GC feels very strongly that you meticulously planned to poison him. As he put it, you practiced on him twice. And that leaves me, though, with the sentencing you on the first degree recklessly endangering safety. As I look at that, the potential is a 12.5-year sentence. And that is something that in the legislature's mind is serious because of the nature and the length of the sentence that is there. I would agree with your attorney that it doesn't have a mandatory minimum, but first-degree intentional homicide also doesn't have a mandatory minimum when it comes to sentencing. So there are certain issues that the court may take, or that the legislature takes into consideration, and just because they don't have a mandatory minimum doesn't mean that it's not a serious offense. So I now turn to what I know about you. And if I've done my math right, you are 51 years old. You were born and raised in Trinidad, one of 5 children. Intact family, where your mother involved in politics and your father farmed.